Our speaker today is Mari Newman, partner in the Denver law firm of Kilmer, Lane, and Newman. Just imagine that you are an employee who has been terminated from your job for reporting your employer's illegal and unethical activities. Or that you are a tenured college professor who has suffered discriminatory treatment during decades of employment. Or imagine that you are being detained at Guantanamo Bay, Cuba. You definitely want Mari Newman by your side. Whether your case is heard in courts in Colorado or elsewhere, she is admitted to practice law before not only the Supreme Courts of California and Colorado, but the Supreme Court of the United States. Her life's work is representing people whose rights have been trampled in the areas of civil, employment, or criminal law. Often, she represents them on a pro bono basis. For her work, she has been the recipient of many honors. Most recently, she has been named a 2009 Colorado Super Lawyer by her peers, an honor limited annually to just 5% of 14,000 licensed attorneys in our state. Not too long ago, Mari was also awarded the 2009 Richard Martin Davis Award, granted jointly by the Denver Bar Association, the Davis family, and Davis, Graham, and Stubbs. This award is presented to a Denver lawyer under the age of 40 who combines excellence as a lawyer with creative civic, cultural, educational, and charitable leadership. In 2008, she was named the Colorado Trial Lawyer Association's Outstanding Young Trial Lawyer of the Year for her representation of persons detained at Guantanamo Bay. She was a co-recipient of the Southern Center for Human Rights 2007 Frederick Douglass Human Rights Award. Mari, along with 2 other lawyers from her firm, represents 5 Yemeni nationals currently being held at Guantanamo. Your Programs Committee recognized this past September that whoever won the November election, the detention of prisoners in Cuba would be an issue we might want to know more about. Mari has just returned from another week in Cuba and will share some information with us today. Please welcome this very accomplished member of the Denver community to our club. Mari.
First, I'd like to thank Sheila for such a nice introduction. What a nice way to start. I feel like I shouldn't really say anything. I should just go sit right down, and then things can't get any better than that. But I'd also really like to thank you for the opportunity to speak to this group. The issues of Guantanamo Bay, I think there's a fair amount of misinformation and partial information, and people's perspectives seem to change quite a bit on this issue the more they learn about it. And I'll note that even here in the audience is another attorney who's been working on these cases. Bill Murray of Holland & Hart is working on these cases as well, and we should all thank him for his work in that regard. The subject matter of litigation on behalf of the prisoners at Guantanamo Bay, I think fits perfectly within the motto of the Rotary group, service above self. These are cases that I and other lawyers have decided to do not for any kind of personal gain or certainly economic gain, but because we believe they're the right thing to do. The case is obviously extraordinarily time-consuming. Until very recently, it's been quite unpopular. And it's quite expensive. The trips to Yemen, to Guantanamo Bay are very expensive, and all of the law firms that are doing these cases are paying for these out of our own pockets because we believe it's important work to do. And the reason why we believe it's so important, particularly as lawyers, is that our country is based on these foundational principles of fairness and due process. And the laws dating back even before our United States Constitution, I know there are a lot of lawyers in this group, which always makes a talk more frightening because the questions are sophisticated. But going back as far as the Magna Carta, there has been a principle called the principle of habeas corpus, which is that a government can't simply hold people, but rather people have the right to challenge their detentions. That is to, instead of being held without given any reason or opportunity to present their side of the story, to find out why is it I'm being held and meaningfully challenge that detention. That's a right that until very recently the men in Guantanamo Bay have not had. And I'd like to give just a little bit of history because I think that that provides some perspective of what we're dealing with here. As probably most of you know, back beginning in January of 2002, the government began housing men in Guantanamo Bay, Cuba. So it's been just about just over 8 years now. And the decision was made to house these men in Guantanamo Bay based on what turns out to be the false notion that by housing them outside of United States soil, they wouldn't be entitled to some of these standard due process protections that are really foundational to our constitutional system. Now that's something that has been rejected soundly by the United States Supreme Court. And the government responded by creating a series of different laws, stripping rights from these prisoners to challenge their detention. There have been 4 challenges that have been brought up all the way to the United States Supreme Court. And in each and every one of those cases, the United States Supreme Court has confirmed that these men are entitled to basic due process rights to challenge their detentions. And so that's where we finally are now, with the opportunity to actually, as lawyers, do something meaningful about the circumstances of our clients who are in Guantanamo Bay. So now we're at a turning point. And just as the internment of Japanese, law-abiding Japanese Americans back in World War II has become a real stain and embarrassment for the United States, I think Guantanamo Bay is going to be viewed in much the same way as we look back on this historically. And I think that this is really illustrated by the fact that in this most recent presidential election, both the Republican and Democratic candidates for president ran on platforms that included guarantees that they would close the Guantanamo Bay prisons. Now, this is a pretty remarkable thing for the candidates from both sides to have agreed on. Both McCain and Obama recognized that our fundamental constitutional government required that we give some due process rights to these men. Both McCain and Obama realized and acknowledged that our system of government requires that if we're going to hold somebody, we need to give them the opportunity to tell us why they shouldn't be there. If we're going to hold somebody, we need to charge them with a crime, give them a meaningful opportunity to defend themselves, sentence them if and only if we can prove they did something wrong. Otherwise, we just need to let them go. So, these are basic principles of law about which the Republicans and Democrats agreed. Obama, as you know, was elected and now has had the opportunity to start effectuating his plan for the closure of Guantanamo Bay. Remarkably, within the very first week of his presidency, President Obama issued 3 executive orders regarding Guantanamo Bay. And for this to have been really his first official presidential act is quite meaningful and quite symbolic, I think. And I was happy to be able to report this in detail to my clients who have been without hope now for many, many years as their children grow up without them. So I want to talk a little bit about these executive orders that the Obama administration has now signed into law. There are 3. The first, and the one that you've probably heard the most about, is the executive order that talks about the fact that the prison is going to be closed within 1 year. Now, people have shorthanded and said Guantanamo Bay is going to be closed within 1 year. The naval base, as I understand it, will continue to remain in Guantanamo Bay, but as people shorthand it, think it's the prison that is going to be closed. The second executive order is that torture is no longer going to be tolerated in interrogations.